and we talk about privacy being based upon using entities to represent who you are. The basic entities that are allowed are your corporations, of course, LLCs, which are in fact our partnerships. For tax code in LLCs, it's either reported as a partnership or as a corporation. So it's one or the other, and they are the same. The concept of a partnership, we used to have in the old days, the general partner and then the partners, and there was no protection for the general partner. So we basically passed LLC laws to limited liability to give some protection to the general partner. The basic use of the two entities, operations, corporations should be the operating company, period. They're the ones that do the business. LLCs are for holding assets that will pass down to the members. We like to use the idea of, apartment building is a good example. You form a corporation to be the property manager of, and that functions as the manager of the LLC, and the owners are the members. The members then use their representation as an AKA called trust. In trust law, there are basically three kinds of trusts: revocable, irrevocable, or business trust. And that's it. I don't care what all the titles are, thrift trust, it goes on and on and on with titles. They're either revocable or irrevocable. What that means is a living trust is revocable. And living trust is a legitimate AKA. IRS says you could have your LLC, one of the owners could be Mahogany Trust. The LLC then, or IRS says that that Mahogany Trust does not exist until your demise. So you get to use it as a legal AKA. And that's really important because the whole idea of privacy is not showing up anywhere. Corporations, we have in Nevada, and there are several states that will allow this, they do not require information, specific information on shareholders. That's critically important. In fact, the most important thing in the shares of a corporation, the biggest confusion people have that I hear every day, the president, secretary, treasurer, and directors are not necessarily shareholders. So when someone serves as a president, doesn't mean he's an owner. That confusion is very difficult because you go into other organizations and you're trying to represent the company and you don't show up as the president of the company. You don't necessarily want to show up as the president of the company because you want to keep yourself as private. So you could be a vice president or a general manager appointed by the directors who could have total management authority. I try not to get it confusing, but you don't have to appear. Nevada has the huge advantage it doesn't share with IRS. All other states do. Now, there's one exception to that. Anyone guess what other state doesn't share with IRS?
Delaware?
Oh, they're the worst. They give up everything.
Hawaii.
Good guess, but no, they've given up everything a long time ago, too.
Wyoming?
No, Wyoming gives up also. I know, good guess also. You're going to be really surprised. In fact, when I say it, you'll go, that makes sense. Ready?
Canada?
Good, yeah, Canada. Utah does not share with IRS.
Utah?
Yeah. Think about that. Our Mormon brothers do not like to give up to the IRS. So there we are. They don't have any special functions otherwise for asset protection, but for themselves not to share that. And here's what's critical about not sharing that information. Once IRS has the information of, let's say you put yourself on as president in your name, Mitch does. And he then is in New York, but he files in New York. When New York shares it with IRS, IRS will share it back with New York, the state, the city that he's in. All that information is cross-referenced because he's serving as president and or in any director position. We have provided this service now for 25 years. Any officer can serve for the shareholder. We provide something called director services, where in fact we are the director of those titles. There's no difference. President, secretary, treasurer, that comes into your bylaws, and it's really meaningless for the scope of what we're doing here. Because who's going to look at your bylaws? Who cares? You know, it gets into really complex issues in corporate law and larger structure. At the level we're at, it really doesn't matter. So the privacy issue, you can serve directors, you can do Nevada, doesn't share. When we do Nevada, we now file them in Wyoming because the fees are much less, but we domicile the company in Nevada. Domicile means residence, and residence is where you give up your information to IRS. So there's like, and it's not gray areas, it's just kind of getting the function down. We provide that service on an annual basis for clients that want to have an address here, and we forward their mail. Basically, we don't get mail anymore anyway, like bank statements or anything. So credit cards, it's all online. So it's just that's the address you gave to IRS for your EIN. Trying to make this sort of like a simple story. So the corporations exist as the manager. For example, I was giving you the apartment building, the LLC. The LLC is the owner. The corporation takes in all the money from the tenants. It then does all the operation of the company. It pays for the vehicles, your computers. It pays for every expense you can think of in the whole world. Writes off everything it can. Then at the end of, and maybe a year, it could be quarterly, whatever, it then can pay profit, to the members. If they so choose, the members might decide to keep it in the corporate structure because they might want to turn the money over into other investments and pay a lower tax than you do as an individual. That's an option you have to the end of the year. That brings up the conversation about S corporations versus C corporations. It's critical. All corporations initially filed are C corporations, separate entities. As if in giving birth to a separate child, it's completely separate unto itself. Now, how does a corporation become an S corporation? The individual that filed the company then goes to IRS and says, I don't want this corporation to have its own identity. I want it to be taxed on my social security number. S stands for stupid. That's all there is to it. There's a couple exceptions. First, we hear about double taxation. Okay, here's the joke about that. You take money in all year long. At the end of the year, you have profit. You decide you want to take the profit yourself. So you can pay that profit to yourself the last day of the year. If you forget to pay yourself, leave it in the corporation and then put it in to yourself the day after the year, you have double taxation. I never met anyone too stupid to pay themselves, ever, in all these years. So the concept. The only other concept that might be more valid, and I had a good example, a young man was a ski mobile guy. And he was going to possibly win some tournaments at the end of the year. And in that end of the year, he could make several $1 million all of a sudden. You're not allowed to make in a corporate structure and taxes all the money at one time and then say it's personal income. They're going to do a double taxation on you. So in that case, when you have the term is uncontrollable income and you need a corporation for removing yourself, you then would use an S corporation. It's very, very rare. And there is no other reason to be an S corporation. Bookkeepers love S corporations. I hope I'm not stepping on anyone's toes here. The reason is They're lazy. It's easier for them. They write down all the numbers on one form, all your business applications on one form, and they turn it in. S corporations are the highest audit rate in the country. I want to repeat that. The highest audit rate. C corporations are never audited with these exceptions. Failure to have employee withholdings, excessive incomes. I'm talking about small income companies. So C corporations basically are never audited. So why do they argue? The fact is, in corporate law, an S corp or a sole proprietor and a C corp, the write-offs are the same. So they'll write that, okay, they're the same. But it's easier to see who you are because you're all there as one person, where a corporation is by itself. They don't see the individual. They're not connected at all unless you get some income, and even then, it has nothing to do with the C Corp audit. Okay, so you can't maintain your privacy totally. There is no exception for wanting to be an S corporation. And bookkeepers, many times, and I'm telling you, I've seen it over the years, it's just laziness. It's just so much easier than two separate returns that has all the same numbers, because then they have to cross-reference everything. They have to think out what the individual was doing versus what the C corporation was doing. It's just more effort. So that's that. We mentioned LLCs and the idea of series LLCs. Only series LLCs are when you can have a number of real properties placed in the LLC. Series law is different in every state, and I don't know the number. It isn't a large number of states that allow series law. It is beneficial one way and it's negative another. Beneficial is one LLC can handle all the properties you own. That can save a lot of money. The negative is, let's say you own one LLC and something happens where you draw a lawsuit. Now the asset chasers, and trust me, the lawyers that chase assets are incredibly efficient. What you've done is you've listed all of your assets in one entity. They're protected, but they're still listed. So once you give up, remember, go back to the word, asset protection is all based on privacy. They can't take from you what they don't know you have, period. And so much of what goes on, as I've told my clients, I've said this 1,000, I said it once, the weakest link in setting up a corporation correctly is the owner, because he's the one that wants to give up information. He wants to say, I'm the president, I'm the owner. You don't say that. When you go to try to develop credit, you don't have to give up that kind of personal information. Granted, when you develop, and I can get into credit a little bit and how we develop that for corporations, if that's something you want to hear. Do you? You want to go with that? Okay. Corporations, just simple, have to have age. It used to be 2 years, it's now 3 years. So with age, you then can do these things. You open a bank account, you have to get an average balance. An average balance takes 3 months for the bank to report that average balance. Next, once you have an average balance, you then go off to all of the corporations in the world that offer corporate credit, i.e. Office Depot, Dell Computers. Just think of all these companies. As long as they report to Dun & Bradstreet, you get all of their forms. While you have that 90 days going by, you fill out all the companies you think you might use credit with, you send them all off. Within a matter of weeks, you'll get back credit. That average balance was critical. I always the story again, 10,000 is better than 1,000, 1,000 is better than 500, and so on, right? 10,000 is a magic number if you can let it sit for the 3 months. And average balance, something people don't ever get. Average balance is the minimum you had in the month. So if you had $10,000, but you spent $100 one time, then your average balance went down under the magic 5-digit figure. There's little things to keep care of. Another rule in law, balances, average balance. If you spent $10 today and you put $10 in today, you did that every day, your average balance would be a negative $20 because banks do not count the money into your average balance for 48 or 2 business days. So you have to be careful of these little rules if you're kind of watching the budget. Now you send off all those credit applications, they'll all come back with that nice average balance, and you'll get a pretty good little statement because you've got the age, you've got the basic 101 of money and age. Next step, as soon as you get them, you go off and you buy something. You have to spend something on your credit to get credit. We all know that. So you go buy something. As soon as the bill comes online and you can pay it online, you pay the bill immediately. Once you have paid all the ones you were going to pay, you have to wait as much as 30 days. Then you can go to Dun & Bradstreet and you report who you are with your average balance, with whoever you have developed your credit with. Now there's another little gist of this. If you had continual business, gets a little confusing business before that you operated. When you bought a shelf company, you can merge that previous history into the corporation and you can report that and you go to whoever you have credit with and you report it to them that it's now Acme Holdings. Then you can report that to Dun & Bradstreet also. So now what you have, Dun & Bradstreet will take that information, will gather it up, and about a month later, you'll have a Dun & Bradstreet rating. And that's the first step in having real credit. I'm trying to think that's it. It's that simple. Then you develop it from there. And that, I think we all know how to develop credit once we have it. So in corporate credit, here's something that people don't know. There's no such thing as a MasterCard. There are no such thing as a credit card like a MasterCard or Visa. It's corporate, period. All of those have your Social Security number. If you work with General Motors and they give you a card, it's because they have what's called a primary membership with Visa. That's a bank license. That's a whole different situation. We don't live in that world. So people think again, there's no such thing. There are corporate credit cards for, like if Dell Computers, all of those other kinds of specialty cards they issue. Those work. Credit. So that's the credit issue. LLC, the asset protection thing. Mitch, what else can you think I need to throw out?
When you're when you're opening up a bank account and you get a credit card issued, let's say through the bank, MasterCard, Visa, speak a little bit about that.
Okay, good. You're not getting a credit card, you're getting a debit card. And we all know the difference.
Yes, we do. They issued both to me.
Say again.
They issued both.
Well, yes, but a credit card is not a credit card based on the business. It's based on who you are.
That's true. And in addition to which I asked for a high line of credit. They gave me a line of credit, which I've steadily asked to increase each month. And they've granted that. And
in the old economy, before the recession, they were just huge. I mean, we were just allowed to have everything we wanted. It was amazing. Today, they're very, very, very conservative compared to how it was. But those are not corporate cards. Those are individual cards.
Right.
And they're with your personal guarantee. So that the idea of corporate credit is when the corporation is guaranteeing. So then we go on, let's say you want to use the corporate credit and you want to go buy a vehicle and you've developed the credit. This is funny. Credit is subjective. There is no rule in stone who and how someone can loan you money. Every bank, every financial institution has its own rules. So because you get turned down at 2 places on your corporation doesn't mean you'll get turned down at the 3rd. You have to know kind of how to word yourself correctly with them to understand that they will make up their own rules. And it's really that simple. On all credit and at the level, there's banks, they have interesting programs today out there for people that want to do investment financing. You really have to work at it, though. You can't just kind of go in with your little basic credit. They want to see business plans. They want to see financials. They want to see more information of what's going on. The deeper the request, the more information they'll want to have. And the days before the recession, it was amazing. They were giving out money to everybody. It was just amazing. So that's the corporate, again, asset protection, C corporations, and they are magnificent. All the rest for protecting your assets. Trust law, I like to give a little words or something. Here's a trick that you should really pay attention to. When you form trusts, you do not have to name what kind of trust it is in the title. Irrevocable, revocable. Doesn't have to be on the cover page. Many people think you have to declare it right away. The signature page is what is critical. Now here's the trick. You could file, let's say you file an entity, and at the same time you're filing your trust. Your trust may have a signature page, an asset protection page, or your not asset protection, your beneficiary page, and then it has the signature pages. They have to be notarized to stand up. The irrevocables have to have state, some simple language that says it's irrevocable versus a living trust. But when you file, like let's say you go to escrow and you give them, many times they just want the cover page with the next page and the beneficiary page, and escrow companies are not very sophisticated. They don't know to ask for the signature page. So you have these assets now placed in mahogany trust. Mahogany trust can be revocable or irrevocable depending on how you want to declare it. So you have your little drawer, your safe there, and you have both signature pages. So if you pass away, they go to the living trust and it passes to the beneficiaries. However, if you get a lawsuit chased after you and they're pursuing you and you're in front of a judge and you get to declare if you have a living trust or an irrevocable trust. And then you go to the drawer and pull that one out because they want to see the copy. Now, it's only pages you have to have are the pages I just mentioned. Okay? They'll want to see the whole trust. So that's when you have to push the button and have the lawyer draw up all the paperwork in between. But it's only those first and back through those 3 pages. The beneficiary page is important too. And you have the grantor page, and irrevocable. Do we need to get into that? You have a grantor, and the grantor and the beneficiaries have to be someone else. Irrevocable means that you have no control over it. You don't own it. You've given up total control. But that way, if someone does a debtor's exam against you, they cannot take it from you. And you have your beneficiary stated with a trustee. You're the grantor. I said that wrong. And you granted the beneficiary to have control over what goes on, and you assign a protector. Protector is usually an independent attorney who has the right to go in and change who the trustee is if they deem the actions were not according to whatever the trust rules were. And this can go on a little bit more and more, but it isn't that complicated. And if anyone thinks they have the potential of ever being sued, unlawful conveyance, a very important term, means the date of the event. When you have a trust, an irrevocable trust, the date of the irrevocable trust has to precede the date of the event of the lawsuit. Now that should be real clear to everyone. If it came afterwards, it has no effect at all. So, and I have prevailed, I've explained to Mitch, because my irrevocable trust formed in 1998. So, and there's nothing chasing afterwards, so we're all good. Oh, geez, what else? Think about it, Mitch.
Could you go a little bit into, if this is the way it can be, how an irrevocable trust can be controlled by you?
Well, what do you mean by you?
If you don't own the assets,
you don't have control. You've given up control.
So how do you control it?
The protector is your control. In other words, you've set down in the rules, when you assign a trustee, that trustee is supposed to have some rules set. And the guarantor is the one, excuse me, the protector is the one that can go in and remove the trustee if he's breaking those rules. That is the only protection you have, is that your protector, and you can change protectors by using the trustees and yourself if you feel that they're not, they die. Well, you have to sign a new one, and you don't necessarily want the trustee, so the grantor could go in and have authority to have that. The protector is the one that would put in the new trustee, but the grantor could assign a new protector. Okay, and so it just depends. If we live long enough, we outlive everybody, so we have to find a way to keep these things, operating. But that's it. And it really, trust law, it's hard to break it down. It's been around forever. We know that. So just separate the two, revocable and irrevocable, and stay clear of whatever else you think go there. Well, let me see. Corporations, LLCs, partnership law. Partnership law is really LLC law. They're just the same. The agreements are almost the same. So you don't really need to go there. Use your LLCs. And remember, you have your members. Your members are owners, and the corporation is separate. And they're great for doing lots of different kind of businesses. Here's another small example of a restaurant. We're all familiar. A restaurant needs 3 entities to operate correctly. If the restaurant owns the property, it needs an LLC for that property. The operating company is the operating company of the LLC, and it's the one that actually operates the business on a day-to-day basis. And then last, all of the stuff in a restaurant, all the equipment in a restaurant, that's a holding company. That is separate from the two because you get depreciation and write-offs and all the others. So 3 separate entities to operate a restaurant properly. I use the example, we had a very famous Mexican restaurant chain. Had 6 or 9 of them, I forget, years ago. They got a lawsuit. All of them were in one corporation. They lost everything. So rather than just having separate entities, and that's the whole thing. Don't lump assets together. Insurance is always a waste of time if everything goes perfect in your life. Is that easy to understand? There's no reason to have insurance if everything's perfect. You don't need health insurance. You don't need life insurance. Everything just goes along perfect, right? Well, most of us don't live in that world. So keep in mind that these corporate structures, et cetera, are in fact insurance. That's all I can think of. So any questions from anybody?
We have 1 second. We have 3 minutes. Go ahead.
This is Marty. So I have one question. So I have an attorney that's going to put he's setting up a series LLC for me, and trust is going to own the series LLC. Each property will also be in a baby LLC, and a trust. That baby LLC will be the beneficiary of an individual trust. What, as far as you were saying that you don't have to declare revocable or irrevocable, what should I look for in the documents that they create? Are there any specific, big major things you would say, hey, make sure they set it up and it has this or that or whatever?
Well, is it going to be irrevocable? Is that what you're saying?
Yeah, there'll be land trusts.
Oh, excuse me?
Land trusts.
Yeah, but is it going to be revocable or irrevocable?
Well, yeah, revocable.
Okay, so see, that's a living trust. And just as long as the title stays clear, that doesn't protect anything. That is just a beneficiary clause. That's how you give the beneficiaries, that's all.
Yeah.
and just don't make sure they don't put your name on any of the covers. I told this little thing to Mitch. It's kind of a joke. In Nevada, all of the landowners are public record of every piece of land. Okay, now that's easy. If you once a year, it comes out in the newspaper, all of these. And if you look at all the ones that have the word trust, 75% of them use the name of the beneficiary with the word trust. Well, that's blowing the whole asset protection out the window. That just doesn't make any sense. You never want to give up your name.
So my name should only be on the last page, you said, the signature page?
Yes. Look at that very carefully. And if your lawyer puts your names it after you, don't say that up. You know you have an idiot for an attorney. Excuse me. I'm just letting you know.
Yeah, I know he's not going to do that.
Okay, good. I didn't mean that, but I'm just letting you know. If someone gives up that information, they don't have any concept of asset protection.
Well, should they even call it like the ABC Land Trust, or should it just be ABC Trust? I mean, if it says ABC Land Trust, then somebody would probably assume, well, that's a revocable trust.
Well, you would prefer them to think it is irrevocable if possible. Yes.
Sure.
And
we've got 10 seconds, 8